Okay, good morning everybody. I'm Kristen King, a director in KPMG's advisory practice, and I'd like to welcome you to the first of 3 webinars aimed at matters that we expect to be particularly relevant to the TCSP sector in the coming months. Hopefully they'll also be of interest more widely to directors and in particular for today's session. And these have been created really in response to a number of queries that we've had from you over the last month or two. So hopefully you'll find the content particularly relevant at this time. In this first webinar, our focus is going to be on directors' duties and responsibilities. And next week, we'll then discuss solvency considerations and practical tips before on the 9th of July, considering accounting for investments, which has been particularly difficult in a time of variable economic conditions, such as those we're currently experiencing. We hope that these topics will assist you not only in managing your own businesses, but also those of your clients. If you have any questions today during the webinar, please submit them to webinars@kpmg.co.im and we will try to respond to them most likely after the webinar, but if there are any that we can deal with at the time, we will try to. The webinar will be available later on today for those who've missed it, or if you wish to listen to it again, and that will be on the kpmg.co.im website. For today and for next week's session, I'm joined by Catherine Ridge, a senior manager in our restructuring advisory team here at KPMG. And today and next week as well, we're also very pleased to be joined by Peter Clucas, who's Managing Director and Head of Litigation at Cains Advocates. And with him is one of their senior legal advisors, David Doyle. David's the former First Deemster and the author of a number of leading Manx judgments on the duties of directors. Together with other colleagues at Cains, they advise a number of TCSPs and indeed the Isle of Man Financial Services Authority. So you could say they have significant knowledge and experience of these issues. Their purpose today is to try to offer some useful information and assistance to enable you to survive any directors' duties challenges that you may experience in the present difficult climate.
Good morning, everybody. I'm Peter Clucas. Today, we're going to talk about duties of directors in a COVID-19 climate. It's increasingly important in the present climate that directors are aware of their duties and responsibilities, which will come under increased focus and scrutiny. We intend to cover specific questions, such as what a director should do in a certain scenario where there is a conflict. It's not our intention to preach to you on dry legal academic topics, although being lawyers, we may slip into that mode from time to time. We know you are out there facing the reality of the sharp end of TCSP business in a very challenging climate. What we aim to do in the limited time available to us, and we appreciate that it's difficult for you to listen to lawyers for more than 15 minutes, and our slot is at least twice that time, is to outline at fairly high level some of the relevant legal principles that you need to be aware of if you are, in today's jargon, to stay safe. In addition to the broad high-level overview, we'll try and offer some practical tips that you can take away from this seminar to increase the chances of staying safe. If I could now turn to my colleague, David Doyle. David, could you kick us off with any particular areas we need to be aware of?
Yes, thank you, Peter, and thank you to all of those who have logged into this webinar, and thanks to KPMG for hosting it and inviting us to address you on these important matters. The island's judiciary and the regulators have recently reiterated the importance of maintaining and enhancing the island's reputation and the high standards required from company directors. To make those points good, I simply refer to Deemster Kamisa's comments in his Montpellier judgment last year, no ducking the serious issues in that case, and Deemster Corlett's comments in Templeton in 2013. But let me balance those comments with a couple of reassuring quotes from English judges. Mrs. Justice Lang this year stated, and I quote, it's on the screen there, "The use of complex offshore corporate structures or trusts is not, without more, a ground for believing that they've been set up or are being used for wrongful purposes such as money laundering. There are lawful reasons, privacy, security, tax mitigation, why very wealthy people invest their capital in complex offshore corporate structures or trusts. And then Lord Justice Haddon Cave, in an English appeal case last year, also recognised that, and I quote, "Businesses and individuals often use offshore structures as part of the normal and legitimate way in which they deal with their assets. Such legitimate reasons may properly include tax planning, privacy, and the use of limited liability structures." Two great quotes there. And once the borders are reopened, perhaps we should put them up in flashing neon lights at the sea terminal, at Ronaldsway, and in Tynwald.
I agree, David. And it's good to see English judges at first instance and appellate levels noting that there are lawful reasons as to why wealthy people might use trust and corporate structures in places like the Isle of Man.
Yes, thanks to the English judiciary for those wonderful quotes. And maybe it's naive of me to hope that some of the international bodies that review us from time to time will take notice of these well-informed and objectively considered judicial comments from across the water. If you only take one thing away from this webinar, take those reassuring quotes with you to bed tonight. It might help you sleep just a little bit better. Because not only are the regulators watching you, but so are the judiciary, so are your clients, and so are those who deal with your clients, and so, of course, are your creditors. No pressure there, then. Failure to properly execute the duties of a director may result in penalties being imposed in the context of civil, criminal, and regulatory proceedings. Moreover, it could lead to the disqualification of the director, or indeed the revocation of a regulatory license. Again, I say that not to strike fear in you, but to emphasize the real importance of this topic. It's not just a case of, oh, I'm legal, I'm decent, I'm honest, I wouldn't do anything dishonest, and I'm reasonably competent, and I use my common sense, so everything will be just fine. Unfortunately, it's not quite as simple as that, although honesty and competence are very good starting points. If you think that something is not quite right, then you're probably right, and you need to consider it in further detail. Consider it in the context of your duties, and consider it, if need be, with the advice of an advocate.
Thank you for those timely warnings, David. But perhaps I could now ask you to get down to the meat. Who are directors' duties owed to, and what are the main duties that we need to be aware of?
Oh, you want some meat, do you, Mr. Clucas? I'll give you some meat on the bones, and I'll serve it up as follows. In Manx law, the duties of a director are owed to the company, not normally to individual shareholders or creditors, but of course directors must have careful regard to the interests of a company's shareholders and its creditors, and in an insolvency situation, regard to the position of the creditors becomes especially important. What then are the basic duties? There's an awful lot of law on this, but in my former capacity as a Deemster, I tried to outline some of the basic duties in Belgravia Corporate Services Limited, some 15 years ago now, when I was a mere judicial pup. And I quote from that judgment as follows. A, to act in good faith in what the director believes to be the best interests of the company as a whole. B, to exercise his powers for the purposes for which the powers were conferred. C, to exercise his powers fairly as between different sections of shareholders. D, save so far as permitted by the constitution of the company, the Memorandum and Articles of Association, of course, not without the informed consent of the company, to put himself in a position in which his personal interests or duties to others are liable to conflict with his duties to the company. And E, to exercise his independent, underline that word, independent judgment in relation to the exercise of his powers, and not to abdicate them, or save where necessary in the interests of the company to fetter them, or save where permitted under the constitution of the company, or where necessary in the interests of the company to delegate them. It is really important to stress that as a director, you must exercise independent judgment, as Deemster Corlett and the Appeal Division explained in the Templeton case. Deemster Corlett, now the island's first Deemster, in effect our Chief Justice, stressed the need for each director to take responsibility to safeguard the company's interests and not necessarily rely on what they are told by a fellow director. Indeed, the Isle of Man's highest court of appeal, the Judicial Committee of the Privy Council, in a judgment in 2015, held that a director breaches fiduciary duty by causing a company to enter into 3 specific transactions on the express instructions of the respondents without exercising any independent judgment as to what was in the best interests of the relevant company.
Thank you for that high-level, broad-based overview, David. I know you've always been a big fan of the hit parade, so can I ask you to give all our listeners your top 10 of practical tips?
Oh, you don't just want meat, Mr. Clucas, you also want practical tips. You don't ask for much, Clucas, do you? Well, I'll give our listeners, or at least those that remain, some practical tips. David Doyle's top 10 practical tips, brought to you today by accountants KPMG and leading advocates Cains, are as follows. Coming in at number 1, whether you are a director of a trust corporate service provider, a TCSP, or a director of an underlying company, you need to be conscious of your duties. And at number 2, you should always exercise independent judgment. Those important words again, independent judgment. Do not act as a puppet with someone else pulling the strings. Do not always do what others tell you to do, especially if it's not the right thing to do. And a podium finish at number 3. You should review all material contracts and where possible and desirable, seek to renegotiate them or terminate them if cost control means it's absolutely necessary. At 4, you should check the company's financial information and cash flow position in order to monitor the implications for the solvency of the company. At 5, you need to have regard to the interests of shareholders, employees, clients, customers, creditors, and others. At 6, you should document your efforts to comply with your duties and state the reasons for your decisions, and where professional advice is taken, carefully note that advice. At 7, you should review the provision of insurance for directors. And a new entry at number 8, post-COVID-19. You should review and where necessary amend your articles of association in order to allow for hybrid, wholly virtual shareholders and directors meetings. And at 9, you should keep all stakeholders, especially the regulators, on side. Cash may indeed be king, but open communication and cooperation is key. And still in the charts at number 10, a worn out record, but an essential part of any good discography. Cracked from repeated use over the years, but nevertheless cherished. If you are in a difficult situation with possible or probable personal liabilities, take professional advice. That is David Doyle's top 10. Have I missed anything out there? Anything to add to that, Peter?
Well, I'm certainly not going to ask you to take us through number 11 to number 30, but I'd like to go back to the point you made at number 5 in your top 10. This webinar is addressing director duties in the challenging climate arising from the C-19 pandemic. And I really want to emphasize, and it's a point that we'll keep coming back to, the importance of having regard to the interest of creditors in particular if insolvency is an issue. This is, as I say, this is a point that we will come back to later in the webinar. I also want to stress that there are inherent conflicts faced by all TCSPs between their duties to the company or trust beneficiaries, as the case may be, and the commercial self-interest of doing what the client wants. It is important to avoid self-interest when considering what is in the best interest of the company or the trust. You have to be especially careful in respect of conflicts between client companies where the directors of both boards are provided by the same TCSP. By way of further practical tip, and this is at no cost, reference can be made to the Financial Services Authority's comprehensive guidance on the responsibilities and duties of directors under the laws of the Isle of Man, which is available, as I say, free of charge on its website. The status of the guidance is stated to be as follows, and I quote, "The authority issues guidance for various purposes, including to illustrate best practice, to assist license holders to comply with legislation, and to provide examples or illustrations. Guidance is by nature not law. However, it is persuasive. Where a person follows guidance, this would tend to indicate compliance with legislative provisions and vice versa." End of quote. So the guidance is important. And David, I know modesty prevents you from confessing to the fact that you assisted the Financial Services Commission, as it then was in the 1990s, in producing the initial draft of this helpful document, which has been updated over the years. It is still very useful guidance. Lawyers in particular like it because throughout the guide, in bold, the following appears. Again, I quote, "Where a director is in any doubt, they should take appropriate professional advice." And another quote, "Directors who are unsure about their duties as a director in any particular set of circumstances should seek professional advice." End of quotes. As I have mentioned your role in initial drafting of this guidance, these wise words have all the hallmarks of your signature on them. On a serious note, this is sensible advice. It will help you stay safe. Treat it as an additional insurance policy. Legal advice will help you and your clients and those dealing with them avoid civil, criminal, and regulatory potential pitfalls that, if not avoided, can result in disqualification, removal of license, loss of business and financial livelihood. Scary, but true.
Thank you, Peter. Can I now just refer to 4 particular areas of concern, especially in difficult financial times? And they're also touched upon in the Financial Services Authority's helpful guidance. These are big topics, but I will try and cover them very briefly. Firstly, directors should be aware of potential liability on a constructive trust basis if they're engaged or they assist in wrongful conduct. Secondly, Section 259 of the Companies Act 1931, which also applies to 2006 Act companies, makes provision as to the personal responsibility of directors for fraudulent trading. We do not have the English concept of wrongful trading in Manx law. Aidan Tucker of KPMG touched upon this briefly in his helpful contribution to the webinar on the 15th of April 2020. One of the leading Manx cases on fraudulent trading is Pecan Hall, decided on the 4th of June 1982, even before I was called to the English and Manx bars. It is that old. In that case, Deemster Luff, a leading commercial deemster of his time who also dealt with the SIB bank collapse cases, held that a company carrying on business and incurring debts when, to the knowledge of the directors, there was no reasonable prospects of the debts being paid, may be properly inferred to be carrying on business with intent to defraud creditors. So watch out for Section 259. The director sometimes has to walk a tightrope in this area. Any thoughts or words of wisdom to share, Peter?
Yes, there will inevitably be cases where it's obvious that directors are trading fraudulently, and it's from those examples that perhaps some practical guidance might arise. The case of Pecan Hall, to which you, David, have referred, is a good example. In that case, the directors failed to keep proper accounting records, from which the court inferred a degree of recklessness towards the protection of the company's creditors. This was compounded by evidence that the absence of proper records was concealing financial difficulties. However, the real fatal blow was the director's decision to continue to trade and incur liabilities after the company had received expert advice that it was insolvent. In hindsight, Pecan Hall is a classic example of reckless behaviour in disregard to the interests of the creditors, from which the court, in my view, had little difficulty in finding that the directors had intent to defraud creditors. What is important was the finding that the directors, and quote, showed reckless indifference to the interests of their creditors by continuing to incur debts when they knew, and if I can emphasize the finding that they knew, that there was no reasonable prospect, and if I can again emphasize the words reasonable prospect, of repaying them. My practical advice is to firstly keep proper accounting records, from which you, as directors, know if the company is running into financial difficulties, which might impact the ability to pay creditors. Secondly, take advice and act on that advice if that situation arises. Please remember that fraudulent trading is a statutory remedy only available within the process of a winding up. So the insolvency or risk of insolvency of the company is the red flag not to be ignored. It will be much more difficult to construct a case against a board of directors of reckless indifference to creditors, where the board has reacted promptly and acted on independent expert advice. I can hear you out there saying that in practice, the beneficial owner doesn't like you as a board running off to take expensive legal or accountancy advice in these circumstances. Or worse still, he or she expects you to carry on the business as normal. All I can say is this: it will not be the beneficial owner who is found personally liable for fraudulent trading.
Very true, Peter, very true. There's wise and practical advice there. Mind your backs. The next section I'd like to take our listeners to is section 260 of the 1931 Act, with the rather old-fashioned and somewhat quaint title, Power of Court to Assess Damages Against Delinquent Directors, etc. Section 260 was applied in the Van Accumulators case in the early 1980s. I helped Jeff Carron out in that case as a very young English barrister. We acted for the liquidator Steve Morehouse, so I remember that case well, and the following year I qualified as a Manx advocate, but less of me and now more of the law. Under section 260, if in the course of the winding up of a company it appears that a director has misapplied or retained or become liable or accountable for any money or property of the company, or being guilty of any misfeasance or breach of trust in relation to the company, the court may, on the application of a liquidator or a creditor or contributory, examine into such conduct and compel the director to repay or restore the money or property with interest, or to contribute such sum to the assets of the company by way of compensation as the court thinks just. The fourth statutory provision I want to refer to is section 261 of the 1931 Act, and it is entitled Prosecution of Delinquent Officers. And it provides that if it appears to the court in the course of a winding up that a director has been guilty of any offence in relation to the company for which he is criminally liable, the court can cause the matter to be referred to the Attorney General for prosecution. That's really serious stuff. So, in a nutshell, watch out for the four main areas of concern. 1. Liability on a constructive trust basis. 2. Section 259, fraudulent trading. And remember, in Manx law, we have no concept of wrongful trading. 3. Section 260, misfeasance and breach of trust. And 4. The nuclear option. Section 261, potential referral to the Attorney General for criminal prosecutions. Peter, I think those that remain on this webinar have heard enough from me, probably far too much from me. Would you like now to accept what I think they call in rugby circles a hospital pass and cover that difficult topic of conflicts, which I guess is a major concern to our listeners? And perhaps we could deal with some specific examples that may arise in practice.
Yes, David. In considering their position in respect of actual or potential conflicts of interest, directors obviously need to have regard to a number of different issues. I've distilled these down to 7 issues, which are on the screen now, but I stress that each case throws up its own unique circumstances, and my list is by no means meant to be exhaustive. Firstly, the general law, and I put that in the context of equitable principles. These equitable principles tend to have arisen in the context of trust law in the first instance, but were adopted into corporate law and now find themselves effectively restated in the form of the main and principal director duties, which David addressed us upon at the early part of the webinar. The provision of relevant companies acts, and David has touched upon a few of those already. I think it is trite law that the Part 5 of the Companies Act 1931 pretty much contains the majority of the statutory provisions dealing with corporate insolvency in the Isle of Man. And I remind everybody that those provisions equally apply to 1931 Act companies and 2006 Act companies through the application of section 182 of the 2006 Act. Thirdly, the provisions of the relevant articles of association, whether they be Table A as modified, or bespoke articles. Too often, in my view, consideration of the articles is overlooked. I'm not advocating that as directors you need to commit the articles of companies to memory. That would be impossible, especially for those directors who hold multiple appointments with companies with varying types of articles. But please always refer to the articles when making difficult decisions as directors. Breaching the articles is low-hanging fruit for claimants trying to construct a breach of duty case against directors. Fourthly, any relevant contractual provisions. Contractual provisions tend to work at corporate level, but nevertheless, directors may be mandated or constrained as to the decisions they can make as a result of existing contractual commitments. Fifthly, regulatory guidance, and I've already referred to the provisions of the FSA guidance. But there is also additional guidance issued by the FSA specifically in relation to conflicts, which I will come on to. Sixthly, practical business realities. Decisions are not made in a vacuum, and you always need to take account of the specific context of the decision that's being made. And lastly, but by no means least, legal and other professional advice. To try and develop this discussion on conflicts, can I invite Catherine to address this? Catherine, you have a specific scenario concerning cash flow and conflict. Perhaps you could just take us through that, please.
Thanks, Peter and David. Good morning, everyone. Part of our previous webinar series, we focused on the importance of managing and forecasting cash flow during this pandemic. It was good to hear this as part of David's top 10 practical tips, and I particularly liked cash is king, but open communication and cooperation is key. But for now, I'm going to focus on cash flow. Not only do you have to consider cash flow the entities for which you are providing trust and corporate services, you also have your own businesses to consider. This can potentially cause a conflict when managing your cash flow. On the screen here is a basic example of a TCSP business to illustrate. For simplicity, this example shows the business running out of cash, but an alternative would be to consider a business that has cash, but not enough liquid capital overall to meet its regulatory requirement. The key crunch points here arise due to the timing of the month-end wages and salaries. The payment of 15,000 circled in week 2. This means that the business will run out of cash, and I've circled a closing cash balance of minus 5,000. You may have used a RAG process to prioritize payments, but what about the sometimes uncertain timing of corporate service debtors? Had you foreseen the impact of the pandemic, I'm sure there's lots of things that you would have done differently. You may have reviewed your client contracts to consider fee structures and ways to accelerate cash flow inflows. For example, the ways in which fees are portioned between fixed or time-based costs, or the ability to bill greater elements as upfront payments, or revisit your charge-out rates in comparison to competitors. Now let's look at one of your SPV clients. First of all, a quick look at the balance sheet. Sorry, it's quite small there on the screen, but on the balance sheet, we'll talk more about solvency assessments in our next webinar, but in the meantime, it's sort of helpful to set the scene. So this is a basic entity which holds property in the UK. The property is at 250,000, which is financed with a loan of 200,000 and is generating rental income. That said, there's likely to be doubts over the value of the property in the current market, and the ability of the tenant to pay the rent may be in question, as in this scenario where the rent has gone into arrears. That's the debtor of 4,000. Now let's look at the forecasted cash flow for the SPV. Certainly, you could process the corporate services payment of 5,000, which I've circled in week 2, which would assist with the cash shortfall in your own business. But if there's no rental income forthcoming, this would mean insufficient funds to pay the tax liability of 3,000 as circled, due in week 6. So here lies the dilemma and potential conflict between directors' duties to your own TCSP business and that of the SPV. We touched on directors' considerations during previous webinars, and that if in any doubt, then seek legal advice. In that regard, I'm lucky to have Peter and David on hand to ask, what should a director do in a scenario such as this, where there is a potential conflict?
Thank you, Catherine. It's Peter again. The key practical consideration is to remember to exercise your duty in the best interest of the company for which you are a director. Accordingly, if you find yourself to be a director of an SPV, but not a director of the CSP, as a matter of law at least, your ability to identify and avoid any conflicts is made a little easier. You must make decisions which you honestly believe to be in the best interest of the company for which you are a director. Only take account of relevant matters and do not give importance to irrelevant issues. If the SPV is at risk of not being able to pay its creditors, your consideration of what is in the best interest of the company needs to prioritize what is in the interests of creditors. Where you think you could pay one creditor but not another, do you risk preferring one creditor over the other? If I can refer back to Catherine's case study of the TCSP with an SPV with cash flow concerns, if I recall the facts correctly, the dilemma facing the directors of the SPV is whether to make the corporate services payment in week 2 and thereby risk that the SPV will not have sufficient cash to pay HMRC in week 6. As is often the case with hypothetical cases, not all the facts are presented to us. As a professional advisor, my first response is to seek more facts and greater understanding of the realities facing the companies and their directors. Let us assume that the directors are on the boards of both the SPV and the CSP. This conflict of interest is apparent to everybody, but in itself, it still may not prevent decisions being made in the best interests of the SPV. The conflict does, however, have the potential, particularly after the event, to colour one's views of decisions made. In this scenario, as a legal advisor, I'd want to know how realistic it is to expect future trading to generate the cash needed to pay all creditors as they fall due, in particular the HMRC in our example. In this example, it is stated that the tenant of the SPV property may not be able to pay the rent, and as we've seen, there is already arrears. More information would be required to ascertain whether the rent will be paid in future, or it will be paid in full, or in part, or not at all. What other sources of finance are available to the SPV to raise cash? How realistic is it that the SPV can trade out of the current cash flow crisis if the interruption to the rental income is only temporary? If there is a prospect to trade out, will the SPV's creditors consider extending credit terms or otherwise giving some forbearance? As was mentioned by David, cash is king, but where it is in short supply, good communication with the creditors, in this case both the HMRC and the CSP, is often best practice. Unfortunately, if after exploring all these avenues, it remains the case that the CSP demands payment in week 2, but the SPV and its directors then cannot see how it will be able to pay HMRC in week 6, or indeed any other creditors, how realistic is it to continue trading? Should the SPV be looking to commence a winding up on the grounds of inability to pay debts, which include contingent and prospective debts? Remember, a winding up is a collective remedy that exists so as to provide an equitable, if not always a generous, outcome between all unsecured creditors. One of the benefits of independent advice, both from accountants and lawyers, in these situations is that whatever decision is taken, it'll be harder for third parties to accuse the decision making of preferring one creditor over another or of fraudulent trading if the directors have taken and considered proper expert advice and recorded the reasons for their decision at the time. If I can put it more starkly, in situations where no advice is taken, if things go wrong, third parties will point to the inherent conflicts as a basis for inferring some wrongful intent on the part of the SPV's board of directors in preferring one creditor over another, or for recklessly trading whilst insolvent. As this example hopefully illustrates, conflicts are never far away in the corporate administration industry. I'm asked the question, what if the creditor you prefer to pay happens to be the CSP for which you work, or worse still, for which you're also a director? In most cases, my answer is that the directors in these situations are hopelessly conflicted and any decision they take without taking independent advice will expose them to a higher risk of criticism after the event. Now, let me cover some general points of law on conflicts. Under the general law, I refer to some Manx common law, which and a case dealt with by Deemster Corran in the early 1990s, one of the BCCI cases, in which he referred to the well-established and inflexible rule of equity that, I quote, "A person in a fiduciary position is not, unless otherwise expressly provided, entitled to make a profit. He is not allowed to put himself in a position where his interest and duty conflict." We then look at the issue of conflicts by looking at the Companies Acts. You have to have regard to sections 148 and 148A of the Companies Act 1931 when dealing with 1931 Act companies, and sections 103 and 105 of the Companies Act 2006 when dealing with 2006 Act companies. I've already touched upon regulatory guidance and its importance, but there is some regulatory guidance on conflicts, and in particular I refer you to the Financial Services Rulebook, especially Rule 6.11, which deals with conflicts generally, Rule 8.9, which deals with conflicts of interest policy and the requirements to have them, and Rule 8.10, Register of Conflicts of Interest. And although regulatory guidance by its nature only directly applies to regulated entities, it is also to a degree a measure of best practice. The FSA rulebook and conflicts were considered by Deemster Comisa in the Isle of Man Financial Services Authority in Montpellier in a judgment delivered on the 2nd of October 2019. And from this, we see the courts clearly have regard to regulatory guidance.
Thank you, Peter. As expected, these situations are extremely difficult for directors to manage, and the appropriate response will be subject to the details of the particular situation. The importance of record keeping and documenting key decisions is essential. If the TCSP is suffering cash flow difficulties within its own business, independent input is always likely to be an important one. Before we hand back to Kristen, Peter, why do you think seeking external advice is often overlooked? We often hear we can't justify the expense.
Yes, and although legal and other professional advice may be regarded by some as an unnecessary and expensive luxury, in my opinion, that misconceived attitude normally ends in tears and the incurring of even greater costs and liabilities. The taking of legal and other professional advice is normally an essential necessity if you're to protect your own position and act in the best interests of the company. But I acknowledge it's not always done, and I think people overlook it because they're concerned over costs. But overlooking it can be a false economy, and it costs much more to try to put matters right later. If I'm looking for other potential reasons, I think external pressures from beneficial owners or parent company pressures undoubtedly also play a part.
Thank you. Yes, the excitement and joy of live webinars. I've just been handed a question that has been logged in from a listener. I'll read the question out and then I'll do my best to answer it live. The question is, from a regulatory perspective, do the requirements for a director to exercise skill and care amount to a fiduciary duty? Interesting question. The answer can be found, my friends, in Deemster Comisa's judgment in the Isle of Man Financial Services Authority and Montpellier Trust and Corporate Services Limited. Peter's just referred to that, 2nd of October 2019. I'm afraid I haven't got the paragraphs off the top of my head, but you can find that judgment at www.judgments.im, and it's in the Chancery Procedure cases, and you can read it till your hearts are content. Peter, the judiciary and the regulators stress the need to keep accurate records and documents. That was also touched upon in the Montpellier case, and Catherine has rightly touched upon this area in this webinar. And as we've got a couple of minutes spare, do you want to add anything to that important topic?
Yes, and it really comes down to being a point which is really for the protection of directors. And it's the need to maintain proper records and documents to evidence and justify decisions, and where legal or other professional advice is taken, to make a proper record of it. The regulators and the judiciary will look at you in a more favourable light if you keep proper records and if you take and act on appropriate professional advice. All what I've been saying. This is for your own protection. Good record keeping can also help directors after the event in showing that they acted honestly and reasonably in all the circumstances. This leads into me mentioning that it might also assist in the argument that directors of a 1931 Act company can ask to be relieved of their personal liability, even if technically they may have been found to breach their duties as a director. Section 337 of the Companies Act 1931 gives the court the power to relieve directors of the consequences of a breach of duty. Sounds good. However, in my experience, the court is sparing in granting such relief, and often exceptional circumstances will need to be in play for the court, in effect, to put the blame on some more deserving defendant. But that was the situation which arose in a case I acted in many years ago, which was decided in the 1990s, in which the court relieved the directors from the consequence of their negligence because, on the facts of that case, the legal and beneficial owner of the company had a separate and overriding duty to protect the creditor claimants, and should have exercised more vigilance over the directors. That said, I'd not like to say that a more modern court would have been so generous to the directors. Relying on Section 337 is, in legal circles, often seen as a plea of last resort. And perhaps to make good my point, the case of Templeton, to which David referred earlier, is a more recent application of Section 337. And in that case, the court refused to relieve the directors of the consequences of their breaches of duty. But nevertheless, the keeping of accounts, records, and the production of appropriate supporting documents will protect your position and avoid the judiciary and regulators looking at your lack of records and supporting documents in a suspicious light. So I really cannot overemphasize the importance of directors keeping good records in the context of decision making.
Okay. Peter, David and Catherine, you've covered a lot of important ground today. The high standards that the regulators and judiciary require of directors, the basic duties owed, the position in respect of conflicts, the importance of maintaining records and documentation to record decisions, the need to take legal and other professional advice to protect your own position, and to act in the best interests of the company. I hope that today's session will act as a reminder of some of the key factors to bear in mind at this time when both you and your clients may find your businesses under cash flow or commercial pressure, and when time may be at a premium. As circumstances continue to change regularly in different countries around the world, it is important to almost continually reassess the commercial and governance risks of each of your client trusts or corporate entities, hopefully bearing all of today's points in mind. Just to give you some dates for your diary, next week we will all be here again and we'll be discussing considerations in relation to assessing and managing insolvency and providing practical tips. Perhaps David will come back with more of his hits lined up for us. And we'll be joined also by a member of our UK tax team who will touch on some of the, I'll give you some tips for interaction with HMRC, who may well be an important creditor for many of your client companies. If Cains or KPMG can help with any particular matters that you're dealing with, please let us know. Seeking independent advice can help to demonstrate responsible decision making and may be cost effective in the long run. The week after next, we will be dealing with valuations of investment, which can be particularly difficult at the moment. We thank you for joining us today. We hope it has been useful. We hope that those topics over the next few weeks will also be of interest. Today's webinar will be available on the website later today. And as mentioned earlier, you can contact webinars@kpmg.co.im if you have any further questions relating to today's matters that you may wish to discuss. So thank you for joining us and have a good week.